Great, thank you. Okay. We are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. We are in fact all sitting in Boston. This is the first case of a hearing list consisting of 6 full cases. This first case will be heard on Zoom. The remaining 5 cases will be heard in courtroom 4. The first case on our list for hearing this morning, well, let me first begin by introducing the panel. Sitting with me on the panel this morning are Justice Catherine Hand, Justice Andrew D'Angelo. We will be the panel for all 6 cases and of course, including this first case via Zoom. The first case on the list for hearing is case number 2021 P824, the Commonwealth versus Alexis Middleton. This is the defendant's appeal. Mr. Gaffney, you may begin.
Thank you, Your Honor. My name is Edward Gaffney and I represent the defendant Alexis Middleton. Mr. Middleton is appealing today the denial of his motion for new trial. The underlying convictions were for a multitude of offenses, including home invasion, aggravated rape, and multiple counts of indecent assault and battery and assault and battery with a dangerous weapon. At the outset, I'd like to focus on the Brady claim in this case. The evidence, the exculpatory evidence that was not provided to the defendant had to do with the background of the 2 DNA analysts that performed the DNA work on this case. Their names were Hillary Griffiths and Rachel Chow. And the evidence that was withheld was included the fact that within months of their work on this case, both Griffiths and Chow were suspended for poor work performance by the crime lab from handling evidence. The poor work performance cited included switching samples and transcription errors. But the evidence, the exculpatory evidence with respect to the background of Griffiths and her incompetence went way deeper. According to her supervisors, during the time period that she was working on the defendant's case, Griffiths, according to her supervisors, was, quote, not able to properly perform her job functions and, quote, not capable of performing day-to-day exemplar work. That's exactly the work that she did in this case. Her job performance was so poor, and her supervisors.
I believe Judge Hand, when she takes herself off mute, will have a question for you.
Oh, sorry.
She does, and my apologies. My question for you was this: that with respect to the failings of the analysts, you don't dispute the judge's determination as to the extent to which, if at all, those failings have directly impacted the evidence in this case. Is that correct?
There is no evidence. The exculpatory evidence does not have any, there is no specific part of the exculpatory evidence that identifies a particular error that was made in this case.
Mr. Gaffney, I'm going to stop you right there because it seems to me that the second part of what you just said stands in tension with your description of the evidence as exculpatory.
Well, no, I don't believe that's the case, Your Honor. It's exculpatory because the entirety of the evidence, it's got to do with not just whether exculpatory is the definition of exculpatory is not restricted to simply things that will prove the defendant is innocent. It's a broad.
I understand it's anything that would erode the evidence of the defendant's guilt. But I guess let me cut to the chase here. It seems to me that of the arguments that you advance in your brief, the most serious seems to be the possibility that due to the sloppiness, for lack of a better term, in handling evidence in the lab, it is possible that the samples of the 2 co-defendants were mixed up.
Well, actually, Your Honor, the critical part of that, it goes beyond that, because it's not just, in other words, the defendant wasn't arguing, look, I've got evidence that these things were mixed up. What the defendant has in a Brady situation, he has to demonstrate that the exculpatory evidence, the evidence that he didn't have at the time of the trial, might have made a difference.
I understand that, but let's as to the mix-up, let me just comment that it seems to me that so long as the two co-venturers were equally culpable criminally on a joint venture theory, it doesn't really matter which of them was the source of the DNA that was found within the victim's swab, right? In the victim's. Okay.
Absolutely, Your Honor.
So to the extent that you instead mean to use this evidence to lodge a broad attack by way of impeachment on the scientific reliability of the lab analysis.
Correct.
That topic was pursued rather extensively at trial, independently of the work of these two chemists, right?
The defense attorney did his best with the evidence that he was given, which didn't.
And not just at trial itself, but before trial, there were experts. I mean, this was not. Everyone recognized that this was going to be a central issue, and since we've eliminated, or at least dampened substantially, any question about the potential that a mix-up would have made a difference on criminal culpability, then the question is, what would the value have been to have some broad attack on by way of impeachment? And it seems to me that there's an awful lot of other effort that stands in corroboration of the reliability of the lab results.
Well, actually, Your Honor, I disagree with the fact that we've established that the attack on the reliability of this DNA evidence didn't matter because either whoever was actually linked to the rape of these two people, both of them were equally culpable. The point here is that the evidence inculpating the defendant was reliant heavily on this DNA evidence. Without it, the evidence was considerably different between him and the co-venturer, his co-defendant, I'm sorry, Nicholson. Nicholson was directly implicated because Nicholson called with Nicholson's phones this person named Tia Hendricks.
No, I understand that, but there's really no serious question that the two of them were not jointly engaged in the entire invasion and attack, and supported one another, whichever of them was the direct principal in committing the more serious acts. It really doesn't matter in terms of criminal liability, does it?
No, Your Honor. I think I disagree with you. The difference here, the two people who committed this crime, there's no question. It doesn't matter which of them was the person who raped this individual. My argument here is that it is not simply because Nicholson was guilty, we know that the defendant was guilty too, because the evidence between the two of them was different. If the evidence of the DNA was not there for the defendant, if this sample was switched, there would have been a considerable difference in the evidence between the two of them as whether they were there. They were the two.
You're suggesting that your guy might not have been established as the other participant in this attack?
Absolutely, Your Honor, because the evidence against him was the indirect evidence provided by this woman, Tia, of a conversation that happened the afternoon before. That was it. That was the only direct evidence that he was a part of this. The fact that she was in a car and there was a gun in the car, and they, while they were there, Nicholson stopped the car, got a gun, another gun, and a bulletproof vest, and then they drove past the victim's house, discussed robbing it, and that is what would have been the entirety of the evidence.
So his participation in the planning the day before would not have supported the inference that he was there the next day when they carried it out.
It absolutely would have supported the inference. In other words, the argument here is not that this evidence, without the DNA evidence, that he would have survived a motion for required finding. The issue on a Brady claim is whether the withheld evidence or the evidence that the defendant did not have might have affected the outcome of the trial. And I just can't imagine a jury simply brushing off the fact that Griffith's superiors knew she couldn't do this work.
Counsel, was there any argument raised that the problems with Griffiths went to the actual admissibility of anything regarding the DNA, that it made it so problematic that it might not be reliable under any type of standard?
No, Your Honor, I don't think that I didn't make that argument, and I don't think that argument is available. It was well within.
So just to and I agree with that, by the way. So the evidence would have come in, and the evidence would have implicated Middleton as the perpetrator, but the possibility of impeachment, throwing some doubt on the fact that he was in fact a contributor of that DNA, combined with an effort to separate him from the planning and the execution, you think would have swayed the jury to a not guilty?
Well, Your Honor, I think that's going a little farther than the standard, which is it might have affected the outcome of the trial. Not it would have.
Yeah, that's a fair point. I'm not seeing much daylight though between the likelihood.
Could I ask a question, Mr. Gaffney, just when you are finished with answering the Chief's questions, can I just hold a place to ask a question on the standard? So I'm sorry if I interrupted your answer.
Oh, sure. I think I was, I'm sorry, Your Honor, you said that you didn't see much difference between might and would change the result.
I think on this evidence, I don't see, I come to the same conclusion, even if you shift it from would have to might have.
Oh, I think that I think that there's a big difference, Your Honor, because I think what the defendant in this posture in a Brady case, what we are at here, and I think this is going to get to Justice Hand's question, we are at the standard of whether this might have made a difference. And as I said, I can't imagine the jury just brushing off the fact that this woman's superiors knew she couldn't do her work, couldn't do this work. And in fact, the Commonwealth is saying, you can rely on this work and you can rely on it. And you know that science proves that he was there. In fact, they went to some trouble in their argument of spending some time establishing the fact that we know the defendant did it because his science tells us. Well, with the Commonwealth arguing, you should have confidence in this. The defendant, I can't imagine the jury is going to brush off a defendant's response to that was like, why should you have confidence in this if her own superiors don't have confidence in this? Okay.
On the standard of review, and I apologize if this is belaboring the point a little bit, but if I understand correctly, your argument, the judge used a federal standard in her decision. And your argument, if I understand correctly, is that it was the incorrect standard to use.
That's right.
The original argument was made on federal and state common law grounds. Is that also true?
Right. I argued it was both a federal, that either standard, the federal is a tougher standard, and I believe that the defendant reached that, but I believe that the judge was mistaken. And I'll.
Well,
yes.
let me just follow up to make sure that I'm following the train. Mm-hmm. And I see that where the judge used the federal standard, but although I understand your client's position is different, the judge found that the particular evidence at issue here was not specifically requested. It was within this, in essence, I read the judge's decision to say it was within the spirit, but not the letter of Attorney Tracy's request for discovery.
Well, what the judge said was specifically, she said it wasn't specifically, this stuff was not specifically they didn't ask specifically for whether somebody was suspended, but right. They did ask for background information, and that request covered the exculpatory evidence that we are here arguing.
Assuming that the judge's finding took a little bit different shading than that, and was that there was no specific request for this, that it was a more general request into which, in the judge's view, the evidence still should have been produced. Why is the state standard under those circumstances for a general request, not a specific request, appreciably different than the federal standard that you say should apply?
Yes.
How so?
Well, the standards themselves are either might have, whether the exculpatory evidence might have affected the outcome of the trial, or whether there's a reasonable probability that the result would have been different.
The real factor, in the
as
words of
opposed
Benedetto,
to
the real factor in the jury's deliberations, that's a state standard under those circumstances, or an articulation of it?
I'm sorry, I missed that question.
Is it a correct articulation of the state standard for a failure to produce under a more general request? And I'm looking at Benedetto for this, but whether the new evidence would probably have been a real factor in the jury's deliberations.
Probably is the magic word, I think, here, Your Honor.
Okay.
Probably, as opposed to might. I'm running way out of time here. I just want to say quickly that the judge didn't just use the wrong standard, but she also mischaracterized three major factual problems. Drugan did not supervise the work of Griffiths, and she never testified that she did, contrary to what the judge found. Griffiths, according to the judge, made several unreported mistakes in her work in 2008 after the trial. That's not true. The unreported mistakes were made back in 2005 and 2006, right when she was doing her work on this case. And at the time of his arrest, Middleton had a Nextel phone. That is the entirety of the evidence. There was no evidence connecting that phone to the attack or the phones in Nicholson's account.
I think we'll have to leave it there. Thank you, Mr. Gaffney. We'll hear from the Commonwealth.
Good morning, Your Honors. May it please the court, Stephanie Martin Glennon on behalf of the Commonwealth. And of course, it is our position here that the trial judge was well within her discretion in denying what is the defendant's second revised motion for new trial in this case.
Attorney Glennon, begin by addressing those three factual discrepancies that Mr. Gaffney alluded to at the end of his presentation.
Well, Your Honor, those actually, I think it's important to put each of those in context as I go along. If I may, I did.
By asking, do you acknowledge that those were inaccuracies?
No, Your Honor. I think it misstates the judge's findings here. The judge's relevant findings here. First of all, the reference to Ms. Drugan as supervising work, I assume is simply a characterization of the fact that Ms. Drugan testified as she was the laboratory supervisor. She was the laboratory unit DNA laboratory supervisor, and in that capacity, she did indeed supervise the work that was done within that unit of the laboratory.
If that factual statement that you just made is accurate, doesn't the fact that she would or that was the supervisor of Griffiths, doesn't everything that Attorney Gaffney say also go to the credibility of the supervisor as well?
Oh, absolutely. Yeah, absolutely. And the trial judge, we're not disputing the trial judge's relevant finding, which is that that as an independent analyst, at most, and this is actually what I take to be eminent support for the trial judge's findings and rulings here, that at most, the information Attorney Gaffney has referred to could have been used at trial to impeach Kaylin Drugan's testimony. We don't dispute that. I don't think there's any issue between Mr. Gaffney and us on that. But as she found, I do disagree with the statement of the state standard to which my brother has referred, and would also note that the judge also applied the Flores-Rivera standard because the defense asked her to. That's in its submissions. So she addressed that as well. But on both standards, she properly denied the defendant's motion for new trial. As she found here, and I think all of this is procedurally very important, the Commonwealth did not withhold any discovery material. The defendant, as she found, did not make any specific request for this particular personnel file material until 11 years after the trial. And indeed, after the hearing, we had the hearing on the defendant's second motion for new trial. He made an additional discretionary discovery request. And that's at pages 100 and 101 of the Commonwealth Supplemental Appendix. She also made the supported finding here that the defendant's trial counsel, he had two initial trial counsel who had their own ex parte DNA expert. And those counsel both said on the record that they were satisfied not only with the voluminous DNA discovery that they received and had available for consultation with their own DNA expert, but also they are on record, as the trial judge appropriately found, saying that they were content with all of the additional discretionary discovery that they had actually sought and the trial court had actually allowed before trial. So here the trial judge ruled only that the discretionary request the defendant made 11 years after trial were referred back, I guess. I'm going to rephrase that. I apologize, Your Honor. The finding was that the defendant's trial counsel in their request for the quote was background information on the analysts, after which they said they were satisfied with what they received. Nonetheless, the trial judge's narrow ruling on the point was that that should also have caused the Commonwealth to require of the laboratory prior to the 2008 trial, whether any of the analysts actually involved in the analysis at the laboratory level in this case had been disciplined or otherwise the source of any corrective action. Because, and this is very important, because the trial judge found, and again, we don't dispute this finding, that because that was not strictly background information as requested by the defense prior to trial, it was, and the quote here is, related to job performance. And I'm fairly sure that's at supplemental appendix page 101. So the defendant here is arguing based on different material. He's arguing these sort of global assaults on the competency of one of the analysts, which my brother is referring to. That material did not even exist within the personnel file until up to 5 years after this trial. And I think that the simple response to that is that the Commonwealth could not have provided what did not exist. It therefore could not have been produced had the Commonwealth made that specific additional inquiry prior to trial. So we get to, and the trial judge correctly got to, the only two pieces of information that could have been responsive and that existed before the defendant's convictions. And that had to do with these two analysts who did not testify at trial. And on regular internal review, these memoranda reflected that the laboratory had detected discrete errors in other cases, but not in this one. And that those had been addressed, remediative steps and training steps had been taken, and then their temporary suspensions were lifted. And so given that that's the only evidence we're talking about, the trial judge, who of course knew the evidence, the totality of the evidence and the conduct of the case best, determined that it wouldn't have made a difference. I just note that she did say it could have been used to impeach Drugan, but that would have been extremely limited. And of course, impeachment material alone is very rarely sufficient to grant a new trial, even in a trial judge's considerable discretion. So I think it's important to note that the accuracy of the DNA analysis in this case was simply not even a live issue. Again, with the defendant having had 2 years since 2006, actually a little more than 2 years, to consult with his own ex parte DNA expert about the particular laboratory analysis in this done, even to have independent testing done had he so desired. He didn't. It wasn't a live issue because the defense to the matching exemplar profile, I think consistent with the reality that if it matched either man who Tia Kendricks positively identified equally, if it matched either of them, it equally inculpated both of them. So the only evidence-based defense was that the matching exemplar profile to the rape kit swab did not inculpate either co-defendant. The defense argument was that it correctly had excluded the co-defendant and that it indeed matched the other buccal swab, but that wasn't this defendant's. It wasn't Mr. Middleton's buccal swab. That was the explicit argument, carefully laid factual foundation in the cross-examination of Trooper Tobin. So the defense was not that there was or could have been any error at the laboratory level in this case. And certainly there's no basis for finding that the DNA evidence would have been entirely jettisoned from the case. It was that, yes, this information could have been used for whatever minimal value in impeaching Kaylin Drugan it had. But on the other hand, as the trial judge noted, it would have been a double-edged sword because it would also have shown that indeed there was regular internal laboratory review that detected errors where they were made at the lab, and that didn't happen here. There was no error detected here. And the defendant's choice of defense to the DNA evidence is certainly consistent with that in saying it was just an input error. They matched an unknown third male whose buccal swab was mislabeled with this defendant's name. And I want to focus on it. The state standard is not whether it might have made any difference in the jury's verdict. Because the trial judge found that no specific request had been made for that additional discretionary discovery, the defendant was required to show that had it been admitted at trial, in this case to impeach.
Attorney Glennon, let me ask you about that specific request. Exactly what request should trial counsel have made regarding an expert from the Commonwealth?
Well, as to forensic investigation, defense counsel framed their requests, and the particular request for background information, there's no dispute. They got all the enumerated background information they asked for. There's not a dispute on that. Some of it was reproduced in 2020 upon the much later request.
My question is, what motion for discovery specifically should trial counsel have asked for that would have uncovered any of these issues if the Commonwealth knew about it? It was a pretty broad request.
It was, and then both counsel said they were content with what they had received in response. The request that would have gotten it was any version of, had any forensic analysts involved in the case either been disciplined or otherwise the source of corrective action.
So your argument
or had they ever erred in any other case, that would have done it, but that wasn't the request.
Records of discipline do not constitute background concerning the analysts?
Well, I guess I can only say that it was only when the defendant made that request in 2020 that it was considered.
Well, I know what happened here, but we're here to evaluate whether that was appropriate, and in order for that to be appropriate, to be outside of the scope, you would have to take the position that records of discipline do not constitute background information regarding the analysts.
Your Honor, I'm not sure I can agree with that. I think the question is, there was no specific request for these disciplinary reports. There was no specific request for whether anyone had been cited for making errors.
There's no specific request for any particular element of background information.
Your Honor, there was.
What does background information encompass?
Oh, Your Honor, there was. It was enumerated, and these materials are included in my supplemental appendix. It was enumerated to include their CVs, their proficiency tests, and they got all of that. And they said that both counsel said they were content with all of that.
Well, of course they were content because they didn't know what they didn't know.
Well, but had they specifically asked and for any kind of record of error in any other case any had made, then the trial court would have had an opportunity to assess
But I'm struggling,
whether that was too
what I'm
broad.
struggling to understand is how disciplinary action taken against the job performance of an employee doesn't constitute background information concerning that employee.
Well, and that is why the trial judge, we're not disputing the trial judge's finding that should have been encompassed. That's why we're here. Then the question is, no specific request having been made for that information before trial. The question is, the burden becomes the defendants on a motion for new trial to show that had this specific extant information been admissible and admitted at the trial, that becomes the question.
But what I'm pushing back against, Attorney Glennon, is your suggestion that that somehow we apply a different standard to assess the failure to disclose this information because it wasn't encompassed within the request. The judge found that, in fact, it should have been disclosed.
The judge also made a specific finding that no specific request had been made for that information, the two pieces of information we're talking about. So in reviewing her decision, the question and the propriety of her denial of the motion for new trial, as a threshold matter, the standard of review would be whether this particular information had been admitted. And in this case, at a trial at which neither party called either analyst, whether it had been admitted to impeach Kaylin Drugan. The question is whether there was a substantial risk that the jury would have reached a different conclusion. And Murray is one of the cases that states that standard 461 Mass 10 at page 11. And I just wanted to go to the next step because I want to have time to get there, which is that the trial judge here was warranted in finding there was no such risk here, whatever standard applies. There was no such risk because even indulging what she found was the defendant's factually unsupported speculation that the swabs could have been switched.
Trial judge's order, and we have your brief on that topic. I think we'll have to leave it there.
Okay, thank you, Your Honor.
Okay. This hearing